Good afternoon, sir. I am Mark Ibasan, and here is my video final presentation in CLG 400 Section J. So, question number 1. Define evidence and explain its scope. Evidence is the means sanctioned by these rules of asserting in judicial proceeding the truth respecting a matter of fact. Scope. The rules of evidence shall be the same in all courts and in all trials and hearings except as otherwise provided by the law these rules. Question number 2. What are the three kinds of evidence? Briefly explain each. Objective evidence are those addresses in the same of the court when object is relevant to the fact in issue. It might be exhibit to examine or viewed by the court. Second, documentary evidence. Documentary evidence as evidence consists of writings, recordings, photographs, or any materials containing letters, words, sounds, numbers, figures, symbols, or their equivalent or modes of written expression offered by the proof as their contents. Third, testimony confined to personal knowledge as a witness can testify only those facts which he or she knows of his or her personal knowledge, that is, which are derived from his or her own perception. Number 3, distinguish corroborative evidence from cumulative evidence. Corroborative evidence is additional evidence of a different character tending to prove the same point. Cumulative evidence is additional evidence of the same kind of character tending to prove the same point. Question number 4. What is prima facie evidence? Is evidence which, if unexplained or uncontradicted, if is sufficient to sustain a judgment in favor of the issue if supports. Question number 5. What is dying declaration? The dying declaration or statement of dying person is a case heresy because it was given outside of the court. Question number 6. What about statement uttered as part of res gestae? Res gestae or things done refers to circumstances, facts, and declarations that grow out of the main fact serve illustrate its character. Number 7. What is the order of examination in individual witnesses? Briefly define each. Number 1. Direct examination is briefly defined in chief of a witness party presenting him or her on the facts relevant on the issue. Number 2. Cross-examination. Its purpose of extend upon the termination of the direct examination. A witness may be cross-examined by the adverse party or relevant matter sufficient fullness, freedom, and number 3, redirect examination. Its purpose of extends after cross-examination of the witness has been concluded. He or she may be examined by the party of calling him or her explain supplements or her answers during the cross-examination. Number 4, cross-examination. Upon the conclusion of the examination, the adverse party may cross-examine the witness on matters stated in his or her redirect examination and also on such other matters as may be allowed by the court in its discretion. Number 8. Briefly explain what is judicial affidavit. So the judicial affidavit rule took effect on January 1, 2013. A normal court proceeding will take around 3 to 5 or even more years to fully decided. So question number 9. An offer of compromise in criminal cases and implied admission of guilt. What are the two exceptions? Number 1. In quasi-officious or acts defined as penalized under the Article 365 of Revised Penal Code. Those allowed by the law by compromise under user examples found in Article 266 Revised Penal Code. Number 10. In order to evidence to be admissible, it must be relevant and competent. When evidence relevant? Evidence is relevant if it has a relation to the fact in issue as to induce beliefs in its existence or non-existence. Number 11. When is evidence competent? Evidence is competent if it is not excluded by the law or these rules. Number 12. What is the order of examination in individual of witnesses? The order in which of the individual witnesses may be examined as follows. A. Redirect examination by proponent. B. Cross-examination by the opponent. C. Redirect examination by the opponent. And D. Recross-examination by the opponent. Number 13. Briefly define each. What is a leading question? When each is allowed. So Leading questions are questions that lead to or suggest the desired answer to the witness. Leading questions are also allowed in conducting an examination upon unwilling or hostile witness or an adverse party, an officer, director, or managing agent of a public, private corporation, or of a partnership or association which is adverse party. Question number 14. What is a misleading question? During direct or redirect examination, the presenting party can only ask neutral questions that do not suggest or desired answer the witness. Some neutral questions are: where were you on the night of 31 December 2019? And how do you know the accused? Question 15. When is circumstantial evidence sufficient to sustain a conviction? Circumstantial evidence when sufficient. Circumstantial evidence is sufficient for a conviction if A. There is more than one circumstances. B. The fact from which the inference are derived are proven. And C. The combination of all circumstances is such as produce a conviction behind reasonable doubt. Number 16. Distinguish burden of proof from burden of evidence. Burden of proof is the duty of a party present evidence to establish her or her claim. In civil cases, the burden of proof to establish the cause of action rests on the plaintiff. In criminal cases, the burden of proof to establish the commission of the crime rests on the prosecution, meaning the prosecution has the duty to prove that the accused committed the felony of offense. Number 17. What is the standard of proof necessary in civil cases? Administrative cases. Briefly explain each. Define what are public documents. 1. Preponderance of evidence. How determined in civil cases? The party having the burden of proof must be established his or her case by a preponderance of evidence. 2. Proof behind reasonable doubt. In criminal case, the accused is entitled an acquittal unless his or her guilt is shown behind reasonable doubt. 3. Substantial evidence. In cases filed before administrative or quasi-judicial bodies, a fact may be deemed established if supported substantial evidence or that amount of relevant evidence which a reasonable mind might accept as inadequate to justify a conclusion. So, what are public documents? So, A. A written official acts or record of the sovereign authority, official bodies and tribunals and public officers, whether of the Philippines or a foreign country. B. Documents acknowledged before a notary public except wills and testaments. C. Documents that are considered public documents under treaties and convictions which are in force between the Philippines and country of source. D. Public records kept in the Philippines of private documents required by the law entered therein. Question number 18. How do you prove and present in court private documents? Private document is a writing deed or instrument executed by private person without the intervention of a notary or other person legally authorized, by which some disposition or agreement is proved or set forth. Question number 19. The original document rule states that when presenting a document as evidence, only the original is admissible. What are the 4 exceptions? The 4 exceptions are the document, writing, recording, and photograph or other record. Question number 30. The last number. Who can become a witness? When is an judicial confession sufficient to sustain conviction? An judicial confession made by accused shall not be sufficient ground for conviction unless corroborated by evidence of corpus delicti. So that would be all, and thank you, sir.